Anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice Catherine Hand. To my left and your right is Justice Christopher Hodgens. We will be the panel for all 6 cases on the hearing list scheduled for argument this morning. The first 3 cases are criminal matters. We will take a brief 15-minute recess following the conclusion of the argument in the third of those cases, and then we will resume with the civil portion of the list. Those of you who've been here before know the drill, but I will go over it nonetheless. Each side of the V has 15 minutes to argue. If there will be more than one attorney arguing on either side of the V, please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. We are familiar with the facts and the procedural history that you've provided in your briefs. We're familiar, obviously, with the arguments as well. We will have questions for you, but my mention of the facts and the procedural history are designed to encourage you not to repeat all of that. We have that. You have 15 minutes to argue, as I said. The light on the podium will be green during the first 13 and a half minutes of that time. It will turn to yellow. That's a good time to begin wrapping up with a minute and a half remaining, and when it finishes, it will turn red and start flashing. At that point, you should conclude your argument unless we have further questions for you. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains, and if you reach the end of your argument before you reach the end of your time, you needn't continue speaking to us. With that, I will call the first case, case number 2022-P-873, the Commonwealth versus Bradley J. Scarbrough, and I'll just remind counsel that this case is partially impounded.
Good morning, Your Honors. Devin Hincapie on behalf of Mr. Scarbrough. Mr. Scarbrough is appealing his conviction of 1 count of indecent assault and battery, and the crux of his appeal is that the trial judge's decision not to give a missing witness instruction was, 1, based in part on an error of law in assessing whether one of the foundational factors had been met, namely the availability of the alleged victim, who I'm referring to as KL, and 2, manifestly unreasonable in the particular facts and circumstances of this case. Before getting to the question of whether it was an abuse of discretion, you have to start by looking at whether the foundational factors were met, and I'll focus on the 2 that are most at issue here. The first was the strength of the case without KL, and the second was KL's availability. Looking at the strength of the case without KL, you start with the trial judge's determination that it wasn't strong enough without her. The Commonwealth's argument at trial and on appeal is that they don't need her. They've got overwhelming evidence of KL's intoxication, and so they don't need her. But I think the reason appeals courts defer to a trial judge's assessment of the weight of the evidence and the credibility of the witnesses is because they're in a superior position to assess that. And here she said it wasn't strong enough. And I think there's a couple reasons why. The first is that the Commonwealth has no idea if this is a case that falls under Commonwealth versus Blash because it never talked to KL. Blash recognizes that there's levels of intoxication, and the fact of intoxication isn't determinative of whether KL consented.
Sorry, I'm a little confused by something you just said.
Sure.
Because your reference to our deference to the assessment of the trial judge, of course, is correct. But ultimately, the trial judge, in the exercise of that discretion, conducted an assessment of the foundational factors and concluded that they were not met. And so a stray comment here or there doesn't provide the full picture of how the trial judge evaluated the strength of the Commonwealth's case, at least not in critical respect as it relates to the appropriateness of a missing witness instruction.
Well, I think, Your Honor, if you look at, I don't think it was just a straight comment. I think she was going factor by factor, and she started with the strength of the Commonwealth's case. She went, the next one was...
I guess my point is that these are factors that are weighed in combination.
Absolutely.
They are not binary switches with a toggle on and off. And so it is the relative strength. She's not saying that the case is weak she's saying that it is not a complete slam dunk, but in so many cases, if they were a complete slam dunk, they're unlikely to go to trial.
Sure. Well, so I started with the strength of the Commonwealth's case because, again, if it's strong enough without her, you don't even get to the other factors, I would suggest. And the fact of the matter is that there was conflicting evidence regarding Kale's behavior that I think is troubling. She doesn't want to go in the ambulance. She's alert and conscious and oriented to person, place, and time.
No, oriented times 2, correct? Not 3.
Oriented times 2.
Sorry to interrupt. Go ahead.
You may be correct, Your Honor.
In my experience, she usually is.
I'm going to defer to the court. Thank you. But with respect to the factor of availability, our contention is that that assessment of that factor, she made an error of law based on her assessment of that of the presence of that factor. She said there was no foundation, and I think that's an error as a matter of law. And the best illustration of what unavailability means, it's an exacting standard in determining whether a witness can be declared unavailable. And
Commonwealth expended some efforts, rather significant efforts, to try to determine her location and was unsuccessful in doing so.
those efforts, I don't know if I cut you off there.
Please.
Those efforts, I think, don't meet the standard, and I think the best way to understand that is by looking at cases such as Commonwealth versus Childs, where this court found the Commonwealth's efforts, which included ordering the BPD to search the place where the witness in that case had been known to live, Randolph, had asked local police in Randolph to look for the witness, had called the witness's father, who'd recently moved to Florida. Dad said son wasn't living with him, and the last he'd heard from him, he was in a jail in Bethlehem, Pennsylvania. The Commonwealth called.
Yes, but this is here they call the witness's mother, who was nowhere near as distant from her circumstances. They contacted a couple of facilities trying to track them down, and to me, at least as important, is the observation that whatever efforts the Commonwealth made or could have made were equally available to the defendant. The Commonwealth, in other words, stood in no superior position to the defendant in terms of being able to secure the witness's availability for trial.
Well, Your Honor, I don't think that's true, because you have from the get-go a order that he not contact that victim, either himself or through a third party. And if he did, that's a criminal offense. So
not for him to do the contacting, but in terms of locating for counsel to find the witness and subpoena the witness for trial. No one is suggesting that he should have taken direct efforts to secure her for her appearance for trial, but this is a formal proceeding, and counsel has recourse.
Your Honor, this is a person that is supposedly the alleged victim of an indecent assault and battery, which has an essential element of consent. If you've never talked to her, you don't know whether she consented. If the police had simply gone to the hospital and asked her, and she said, I don't remember.
But you're not raising a challenge to the sufficiency of the evidence. And there's a good reason for that, because there were multiple witnesses who testified that they observed her in a state of extreme intoxication at the time of the encounter. And as you know, a level of intoxication that has them impaired to the point of near unconsciousness serves as an obstacle to consent.
Absolutely.
And that's the basis on which the jury most likely convicted, the reason why you're not challenging the sufficiency of the evidence. And, it tends to, I guess, mitigate the description that no one could establish whether she consented or not, except for her.
Well, two things I'd respond, Your Honor. First, the symptoms that are described by the witnesses that don't know her, don't know how long she's been there, don't know what she's had to eat that day, don't know how much she's had to drink, the symptoms they describe, slurred speech, difficulty walking, even the smell of alcohol on her breath could be reflective of a diabetic complication.
Eyes rolled back, head unsteady. I mean, this was a pretty full mosaic.
Was there not also evidence that KL told the police that she had drunk the bottle of wine that was found empty on the
She had drunk from it. I don't think there was that she said she drank the bottle
Yeah,
of
yeah,
wine. I think it could have been
Thank
a
you.
shared bottle. And there was also witnesses testifying that she and Mr. Scarborough were actively kissing, that she wasn't non-conscious. And I think there was just it's conflicting testimony on that point.
But could I ask a question just to follow up on the
Sure.
Chief's question? To your point, it doesn't really seem to be disputed whether KL consented and that she was participating in the kissing, but the question really seems to be whether she was capable of offering that consent. How would KL's testimony be more, on that point, really be more than cumulative of the evidence that was provided about her appearance and her ability or inability to communicate with the three other witnesses who testified?
Well, again, if the Commonwealth had never talked to her, they don't know if it's a Blash case. They don't know if it's because she's intoxicated or because she's having a diabetic complication. Those symptoms are the same thing as you would have if you have a diabetic complication. And the ADA even argued at the required finding stage about, look, Judge, look at the EMT records, something about blood glucose in there, and too much blood glucose or too little, and giving that is also reflective of other potential things that may be going on with this witness.
But would it matter, though, if it was intoxication or if it was some other reason that she was incapable of consenting, if that were the argument?
I think it does matter. I don't know that there's any evidence.
Cognition was impaired, in other words, by low blood sugar combined with alcohol. That still has the same impact on her ability to provide consent.
I think we're sort of wildly speculating, and we shouldn't be, and the jury shouldn't have been allowed to, because
I wasn't trying to be engaged in wild speculation. I was simply observing on the suggestion that you offered as a potentially exculpatory version of the same facts. But analytically, your response doesn't take away from the culpability because it still impairs cognition from whatever source. The point is that there were witnesses who observed her exhibiting indicia of a lack of cognitive capacity, and that is the basis, presumably, on which the jury returned a guilty verdict.
I would respectfully suggest that you have an assessment of whether the foundational factors of a missing witness instruction were met, and I think there was an error of law in assessing that particular factor of availability. It's a legal, there's a sort of an evidentiary definition to it, and the Commonwealth's efforts don't rise to that level.
Well,
They don't meet
what
that
more would
standard.
you have the Commonwealth do? The prosecutor said that she obtained a HABE for MCI Framingham, learned that the witness was no longer there and was now an inpatient in rehab.
Sure.
At that point, what more can the Commonwealth do to bring the witness in?
Well, Your Honor, this is the same district attorney's office that has been prosecuting this person since 2007. There's multiple cases out of that district attorney's office. You cannot HABE somebody in who's not in custody. If she's at a treatment facility, you summons her in. The Commonwealth can pick up the phone and call Waltham DA's office and ask them where she is. She can't just go to a treatment facility when she's being held without bail on her own. She's brought into court. Probation, there's a named treatment facility in the record. In fact, several weeks after the trial, probation's bringing it forward because she was discharged from a named treatment facility and didn't check in with probation.
Okay, so you would agree then that the Commonwealth did make efforts to procure this witness's attendance. In other words, this is not a situation where the Commonwealth was intentionally trying to avoid bringing a witness in because that witness might tank the Commonwealth's case.
You can describe anything as an effort. Is it sufficient to meet that evidentiary definition to declare this witness unavailable? Our argument is that it's not. That sending a HABE when somebody's not in custody isn't a sufficient effort. They never summonsed her, and all of the cases talk about when you're looking at what is a good faith diligent effort. Did they summons the witness in? Did they try to secure their presence via the Uniform Act? That's Barber v. Page. Those are, not just Massachusetts case law, but because you have this right of confrontation under Article 12 in the Sixth Amendment. That's why it's so important.
The judge never precluded anyone from making an argument to the jury about the missing witness, right?
She did.
But the
They asked,
co-defendant actually argued that this witness wasn't present.
there was reference to it, in the closing, but I don't think that's the same as giving an instruction. And I think that could have been an error on their part. You're supposed to ask. You're supposed to obtain permission for it. And Mr. Scarborough's attorney did ask, did try to lay the foundation, and was shot down in that sense. So I think the instruction is obviously a much more powerful vehicle for communicating that to the jury, that there's this person here who's literally the only person that could testify on the essential element of consent, and she's not here. They've never even talked to her. I don't think the Commonwealth should be prosecuting crimes where you don't know if a crime has occurred because you've never talked to this person.
Counsel, could I ask one follow-up question?
Sure.
I think you made reference to the fact that the parties were aware that the victim in the case had been involved herself with the criminal justice system for some period of time. Did I understand that correctly?
Yes, Your Honor.
And is that coming from the reference to, the Commonwealth's reference to talking to probation about the whereabouts of
Yes,
that
she
witness?
had an active case out of 2016 that she was still on probation for. She was under a term of probation supervision on that case. And the address, the reason I brought that up is because her address has never changed. It's always the same. It's her mother's house. They didn't send a victim witness advocate to talk to her, or the police. They didn't, pick up the phone. They didn't send her a letter.
Do you know if that was the same address that was on the ambulance records that were subsequently redacted?
Was that the same address that was on what records?
Ambulance records that were admitted into evidence, but they were redacted before they were shown to the jury. Is it the same address?
Yes, it's always the same address that she has on her Board of Probation record. All of the complaints from 2007, 2012, 2014, and 2016. So she's not somebody that they don't know where to find her. Thank you.
Thank you. For the Commonwealth?
Good morning. May it please the court, I'm Dylan Punch, student practitioner under SJC Rule 303 and 3L at Northeastern University. I'm under the supervision of Assistant District Attorney Timothy Ferreter on behalf of Middlesex County for the Commonwealth. The issue before the court is whether the trial judge abused her discretion in declining to give this missing witness instruction, and she didn't, because the defendant failed to establish the foundation for the instruction on the record. First and foremost, the record shows that the victim was neither physically available for trial, and it also shows that the Commonwealth made every good faith effort to secure her presence at trial. The Commonwealth was in touch with the victim's mother and probation officer, learned that she was incarcerated at MCI Framingham, sent a HABE while she was at MCI Framingham. This was 8 days prior to trial. After the HABE was sent, the victim was transferred to this substance abuse treatment facility. And the Commonwealth was not able to determine exactly what facility she was at or to confirm that she was at this named facility because they wouldn't.
Did the corrections facility know where she was?
I'm not positive if with the corrections facility's level of knowledge. The Commonwealth was in touch with.
Let's just take a step back for a moment, because the defendant's counsel certainly has made a very strong suggestion that it's unlikely the correctional facility would allow a person in custody to be transferred to a treatment facility without keeping tabs on which treatment facility they were sending them to.
Yes, Your Honor. The record shows the Commonwealth specifically was not aware. I'm not sure what.
I understand, but the question that we're exploring at the moment is the degree of efforts that the Commonwealth made to ascertain that location. You say that they sent a HABE to the facility, but that's not going to attach to anything if the person is not there. So the question is, if they knew that she was in a treatment facility and she knew that she had been sent there from the correctional facility, they didn't know what the treatment facility is, but surely the correctional facility is a place to ask.
Yes, Your Honor.
And yet there doesn't seem to be any indication on our record that the Commonwealth posed that question to the correctional facility.
That's correct, Your Honor. And the Commonwealth the record does indicate that the Commonwealth was in touch with a treatment facility that would refuse to give out patient information.
I understand, but that's going from the perimeter back in, as opposed to going to the epicenter and fanning out from there.
Correct, Your Honor. Yes, yeah, it does not appear that there's no indication that the Commonwealth was specifically in touch with the...
What are we to do with that?
Well, Your Honor, the Commonwealth would argue that certainly all the good faith efforts were expended at this point, and the Commonwealth was continuing to procure the victim's presence up until trial, requested continuances, and the defendant foiled his attempts by insisting on a quick trial date. So the Commonwealth was more than willing to keep attempting to secure the victim's presence, Your Honor.
The defendant is entitled to have a speedy trial. The defendant's not required to accede to the Commonwealth's request to try and bring a witness in.
Correct, Your Honor, but it just goes to the Commonwealth's good faith efforts and was still actively working to get the victim into this trial. Now, as to the strength of the case of the trial, of course, the Commonwealth would have preferred to have this victim present. Her testimony would have been relevant, important to the case.
Depends on what the witness would have said. That's the whole point of the missing witness instruction, right?
Correct, Your Honor. Yes, and here, the issue was one of consent at trial. However, it was specifically about the ability to consent, whether the victim was capable. And between these four witnesses and the medical records, the Commonwealth presented strong evidence that the victim would not have been capable of consent. We're talking about a woman who couldn't stand, talk. She fell twice and went unconscious. She had to be carried to a stretcher. She didn't know the defendant's name, couldn't keep her eyes open. The medical records, although they do describe the victim as having a level of consciousness that was alert, it also said that she was unable to walk or sign her name due to her level of intoxication. So the evidence presented at trial was quite strong about her ability to consent, Your Honor.
What do we do with the fact that the trial judge disagreed, at least at some point during the argument?
Yes, Your Honor. So the trial judge said she didn't think it was strong enough, but then she went and said it's strong enough to get over the rail. So she certainly seemed to think that at least probable cause was established and there was enough for it to go to the jury at this point. And the jury, apparently the jury was convinced that there was enough, Your Honor.
But how does that impact the judge's obligation to give the missing witness instruction?
Here, apparently the judge, by saying it was enough to get over the rail, I think that counted against the foundation for the instruction, Your Honor. The trial judge, there was a pretty lengthy back and forth between the trial judge, the defense, and the prosecution. It shows this was a carefully considered decision, and the trial judge reasonably said that the foundation was not laid. And these instructions are supposed to be given in clear cases, and the record shows that this was not a clear case. This was less than that. There's quite some arguments on both sides. If there are no further questions?
Let me ask you this. Now, it's not unusual for a judge to decline to provide a missing witness instruction and also to say to counsel, oh, but by the way, you're free to argue that issue to the jury if you wish. Did the judge here put any restrictions on arguments of counsel?
Not that the Commonwealth is aware of, Your Honor. It was touched upon lightly in the closing arguments, but not to the point where you could fairly say the issue was already before the jury. If there are no further questions.
Thank you. Thank you both. The next case on our list for hearing is case number 2022 P846. This is the Commonwealth versus a juvenile, and this case also is partially impounded. I'll remind counsel to avoid reference to any of the impounded material.
Good morning, Your Honors. May it please the Court. My name is Jalin Hwan Nakam. I represent the juvenile. Though I raised two issues in this case, I will focus my argument on the one related to incomplete video footage.
Please move the microphone a little closer.
Yes, Your Honor. My apologies.
Use your outside voice.
Thank you, Your Honor. Though I raised two issues, I will focus my argument on the issue related to the incomplete video footage. but I do first want to clarify that the proper standard of review is abuse of discretion. Here, the motion judge abused her discretion when she admitted videos that only contained portions that were advantageous to its case, where the evidence clearly support there was other portions of the videos that existed that happened outside of the complex. It was undisputed.
Can I ask one question on that
Yes, Your
topic?
Honor.
Just to make sure that I understand. I am aware of the fact that part of the argument is that there are jumps in the video. There are breaks between the times of the video portions that I think it was suggested were in some way spliced or edited by Mr. Cragg, potentially. Is it also your argument that there's a missing initial component to the videos, that there's something that existed before the videos start in the parking lot, and that's also part of your argument?
It is, Your Honor.
Okay.
There were two.
And my question for that initial piece is, what is it that creates where's the foundation for the fact that there was something that wasn't shown on that video?
At the time that the motion was argued, Your Honor, it was undisputed that the evidence, as even told through the Commonwealth's exclusive only witness, Mr. Davis, that the parties were outside of the complex, had a very heated verbal dispute argument, and that argument led to a physical confrontation. That is undisputed. Whether or not who the initial aggressor was, that's something that may not have been particularly relevant for purposes of the motion judge's assessment, but that was perfectly clear. However, the motion judge credited the Commonwealth's argument, suggesting that because they were motion-censored cameras only, that perhaps no footage existed because there was no movement to detect. I understand that the argument is circuitous, but notwithstanding, that is contrary to the evidence that was present at that time, but the motion judge credited that argument.
Sorry, go ahead.
Go ahead.
Wasn't there a segment of the video, there's one segment of the video that appears to be much lower quality than some of the other pieces of video. That arguably includes or is consistent with some of the testimony about how that outdoor altercation, the initial one, began. I'm not asking the question very well, but given the fact that there is footage showing an outdoor altercation that is consistent with the testimony on aspects of the testimony on both sides about that, and there isn't an argument, as far as I can see, to be made that there were two such incidents, doesn't that suggest that all of the front-end video was introduced? The dispute is what it shows?
Two things, Your Honor. My understanding is there is no clear footage of anything that happened outside of the complex. I don't believe that that's disputed. I don't think the government disputes that that does not exist. I know that the witness was brought in to explain the mechanics of how the surveillance cameras worked, and again, the motion judge credited the Commonwealth's argument that this witness would explain away any potential problems that could have explained why that footage was not available. So with 44 video cameras available, only the footage of what happened inside showing my client assaulting the victim was available. None that showed that physical altercation outside of the complex came in.
But the physical altercation inside that was captured on the video that was played formed the basis for the charges and the conviction, right?
I believe that they do, Your Honor.
The outdoor encounter furnished context, but it would not be exculpatory even if the victim were the first aggressor, right?
I would suggest that it would be exculpatory. I mean, if we go back to the issue of whether that was admitted was a fair representation of the incidents as they unfolded.
It's a fair representation of the incident that forms the basis for the charges. There's a lot more video available in every trial these days than there used to be, but it's not at all infrequent that the video doesn't capture all of the evidence of all of the context that leads up to the encounter furnishing the basis for the charges.
In this particular incident, Your Honor, we have a judge relying on two faulty premises. I think I want to focus on that. One being that the judge credited the fact that perhaps that video didn't exist when that was contrary to the facts that was available to the court at that time. Second, there were significant credibility issues with respect to Mr. Craig, who had known the victim since 1989, and that he, as an owner of that business, had a financial stake in whether or not video existed of an adult employee, a former police officer, assaulting a juvenile outside of his complex. I think that there were issues that the motion judge did not fully assess in making her, and exercising her discretion as to whether this goes to admissibility or weight.
All of that, of course, whether or not there was, there could have been other evidence brought forward, other video evidence brought forward. It seems to me is fair game for argument as to limitations on how much emphasis the jury should place. There was witness testimony of the entirety of the encounter, and I guess I keep coming back to an adage that shows in many of these types of cases, which is that the concerns go more to the weight than the admissibility of the evidence, and it's open to the defendant to poke holes in the weight for the consideration of the jury.
Your Honor, this court has decided that a cross-examination or impeachment or challenges to these types of evidence is not necessarily a cure-all. I understand that the motion judge decided, well, this goes toward weight, not admissibility. I will give you wide latitude in cross-examining this evidence. I don't know how helpful that remedy was. The defense had a constitutional right to challenge and impeach Mr. Craig and the evidence that came in. It was, and he did that. I don't think that's disputed. It was a well-litigated issue for the trial.
But what you're then contending is that it was error arising from an abuse of discretion to allow the video footage in that the Commonwealth offered, that offered a very clear image of the clear depiction of the acts giving rise to the charges.
In essence, Your Honor, and I think it was very clear throughout the trial, and particularly in closing, that the video footage that came in was the centerpiece of the Commonwealth's case. As a matter of fact, the victim testified, and it came out that he had holes in his memory and gaps that he used the video to actually fill in those gaps before he testified. It was not one of those situations where he's in the middle of testimony and his memory is exhausted and was refreshed as with the videos. He relied on that in order to prepare for his testimony. And the government used it over and over and over again, and in closing, emphasized it to such an extent and so impassioned about it that the judge, sua sponte, gave instructions to the jury to disregard certain emotional infusion, I guess, I'm paraphrasing, of the attorney's arguments in closing. So this video was so damaging, and the defense was completely hampered in its ability to challenge it, to be able to rebut even the way in which the government utilized this footage.
If you could help me, I'm still trying to understand. There's three separate incidents here as I see it. There's one that's sort of in the vestibule area, and then there's another one that's sort of before you get to the basketball courts, and then there's the other one on the court. And correct me if I'm wrong, but that's the incident on the court. That's where the victim is being struck by these two individuals and they're kicking him. And that's the subject of the charge where he was found guilty, correct?
That's what it depicts, and
okay.
I think it would be reasonable to infer that the jury relied on that.
Okay, so now connect for me, if you would. How is that incident related to the incident in the vestibule that wasn't properly recorded, according to your argument? What's the connection there?
That video footage would have shown, at the minimum, the state of mind of my client, given what had happened outside. I think the fact that the government relied on the footage that came in to make such an impassioned argument, and where the juvenile was not similarly able to make that argument based on video that would have shown at minimum a mutual combat, where my client...
Again, there's no question, no serious question here, as far as I understand it, that the victim's acts captured on the video that was admitted were somehow justified by self-defense or otherwise. So when you talk about the significance of the vestibule, the outside engagement, and refer to state of mind, I'm sharing Judge Hodgens' confusion. How does that bear on the victim's, the defendant's criminal culpability for what was admitted?
The jury was not given a full picture of what happened that evening. They were only given evidence that tended to give advantage to the government and their exclusive sole
But
witness.
I need you to explain how the evidence that they did not get, that you're saying the absence of which precluded the permissible introduction of the video of the beating itself. How did that other evidence exculpate the defendant?
Well, Your Honor, one, the jury could not fully assess the victim's credibility. The defense could only do so much to challenge his credibility, absent this video, where only video footage comes in, corroborates his version of the events. The defense could not cross-examine the business owner in a way that...
What could have been shown, let me put this another way, what could have been shown on the outside video that would have detracted from the criminality of the beating that was depicted on the video that was admitted in evidence?
Your Honor, I think it would have provided a global picture to the jury. I know that I'm going back to my initial point, which is that it would have given them an opportunity to better evaluate the credibility of the victim.
But the credibility, when we've got the thing shown on videotape, the credibility of the victim about the central assault and battery is really not the centerpiece of this case.
Your Honor, the defense could not prepare or to robustly challenge the victim, absent this video, when all they had was video that corroborated his testimony. Giving the defense an opportunity to cross-examine did not cure
Please, just humor me if you would, and just give me an example of something that could have been shown on the outside video, had it been presented, that would have helped the defendant.
I think if the video shows the victim, a grown middle-aged man, assaulting a juvenile, I think that that would be something that a jury would assess in this situation as how the incident unfolded.
How would that bear on the criminality of the activity shown on the video that was admitted? We've already talked about a couple of things. We talked about self-defense. It wouldn't justify, it wouldn't provide a basis for self-defense. I'm just, analytically, I'm having a hard time understanding the exculpatory nature of whatever might have been shown.
I do feel like I'm repeating myself a little bit.
Simply because you haven't yet provided an answer that addresses the connection.
I understand that the court may be focused on whether or not I can address each of the elements of the crime for which he was, that the jury rendered a verdict. I think we need to look at the bigger picture in that the jury could consider more than that, which is the fact that this video, that the government relied so heavily on this video, I think highlights the significance of what that video showed beyond
is your suggestion that somehow that if it described the larger grown man initiating contact, that it would have elicited some sympathy for the victim, if not legally sufficient justification?
It could have. It could sort of highlighted his state of mind, what was going through his head.
State of mind, again, would not have provided a defense, unless I'm missing something. If you have a legal basis that you haven't articulated yet, why state of mind would bear on the criminality?
I think I think what I maybe not artfully trying to say is that the bigger picture would have given the jury a better assessment of all the characters of the victims, or the defendant and the victims that were involved. And here, they were deprived of that opportunity.
Thank you.
Thank you, Your Honors.
For the Commonwealth?
Good morning. May it please the court. Kristen Zhang for the Commonwealth. I'm going to start with the surveillance video issue. The trial judge here clearly did not abuse her discretion in admitting the videos. The defendant presented a claim that the footage was untrustworthy and unreliable given the gaps in the timestamps on the videos. The Commonwealth proffered that it was just because this video system was motion activated, and I provided a description of each video in my brief as to what it showed, and I think it's consistent with what the building owner testified to, that, particularly the footage of the outside of the building. In the one clip that did perhaps show the altercation that clearly happened, both sides admit that some sort of altercation happened outside of the building to start this whole series of events. You see a person in a white T-shirt on the very edge of the footage. It's very plausible to me that something further up in the footage was what was really the motion that was activating the camera. I think there was a flagpole involved, something like that. And
Well, we don't have that established, right?
we don't. No, the Commonwealth did not call some sort of expert to testify on how these videos worked, but just in my view of the footage, it's, what the juvenile is referring to is that first altercation was in the corner of that video footage. And it's very plausible that the building owner was testifying correctly about how they functioned, and that the footage that is quote-unquote missing just never existed in the first place. It was just never captured. And it's very well settled that any concerns regarding the method of storing and reproducing video material goes to the weight, not the admissibility of the evidence. And here, the juvenile had a full opportunity to cross-examine the building owner about how the footage was obtained, cross-examine police officers about why they didn't go in and try to, basically supervise Craig in pulling this footage. And the juvenile also reached this issue in his closing argument, suggesting that perhaps these videos were edited because the building owner had a reason to maybe not show the footage for all the reasons that we just heard in my sister's argument. But this was an issue for the jury to decide. And I'm also happy to answer any questions about the lesser included offense instruction, if there are any, or any questions about the video evidence. Seeing no questions, I'm happy to rest on my brief. Thank you very much.
Thank you both. Brings us to the third of our criminal cases this morning, case number 2022 P789, the Commonwealth versus LAZARO, TRIZAN. And I'm sorry if I've mispronounced the name. You'll correct me if I did. Again, this case, like the other two, is partially impounded.
Waiting for the timer to reset.
You have the clock?
Yeah. Good morning, and may it please the
Wait a
court.
minute, we have to reset it to 15 minutes.
Good morning, and may it please the court. Rachel T. Rose for LAZARO TRIZAN. What's supposed to be the procedure when a probationer is violated based on a foreign statute? The law is clear that a probationer is entitled to a hearing where the judge makes an independent determination that he's either broken a condition of his probation or committed a new crime. A judge can be presumed to know the law in Massachusetts, but the Commonwealth can't point to any case law saying they get the same presumption when it comes to statutes from other states. To be able to say that the facts set forth in the police report constitute a violation of Florida's harassing telephone calls or stalking laws, the judge needed to have the laws in front of her.
Could I ask a favor? Could you just speak a little bit more slowly so that we can hear you more clearly? Thanks.
If she'd reviewed those statutes over the recess, she would have said so on the record. The only case I could find even marginally dealing with this issue is Commonwealth v. Grossi, an unpublished decision from 2003. In that one, they found that the probationer had most likely written the threatening letter at issue in Massachusetts, so they could apply the Massachusetts statute on threat to commit a crime, but they noted they could have charged it as a violation of the federal statute prohibiting threats sent through the mail if the judge took judicial notice of it sua sponte. In other words, where the Commonwealth is alleging facts that might fulfill some or all of the elements of either a foreign law or a Massachusetts law, due process requires more than just a conclusory statement that it's some sort of crime. The Florida stalking and telephone harassment laws aren't even close to the same as the Massachusetts ones. They have different elements and different ways they can constitutionally be applied. The transcript and findings here should have included enough to support a ruling that the police report described something that fulfilled the elements of a particular statute and went beyond the bounds of protected speech.
Your argument seems to be that that the judge must explicitly lay out that process on the record, and yet I'm not aware of any case that says that, or any statute that says that.
The presumption that the judge understands the laws of Massachusetts can cover for a lot of this when we're dealing with
No,
the
it's not a question of
Massachusetts law.
presumption that the judge understands the laws of the Commonwealth of Massachusetts. A judge is entitled to take judicial notice of laws of foreign jurisdiction, not municipal ordinances, but the laws of other jurisdictions. And what you're saying is that it is a requirement as part of that process, if the judge is taking judicial notice, that they state that they have done so on the record. And the cases, I read the cases that you've cited, and none of them says that.
As you can tell from my citations to cases from the 1800s, the case law was a little thin on this particular point.
Well, there's been a lot of time since then, and none of the cases since 1883 has made that statement either. And in the absence of a case that has said or imposed the requirement that you're urging on us, my general inclination would be that to conclude that that is not a requirement, but that you're asking us to make it one.
Well, what would be the distinction then? How could you tell the difference between when a judge has taken judicial notice of something and when they haven't?
Well, we presume that judges correctly instruct themselves on the law, and if they are entitled to take judicial notice of the law. And by the way, when the judge returned from the recess, she offered a fairly detailed description of at least one aspect of Florida law relating to the process. Now, it's possible that the judge confined her review solely to that question and thought that she didn't need to bother determining whether, in fact, the acts described would have been a violation of Florida law. But when a judge goes beyond the claimed violation and looks at the procedure of how it is handled in Florida, that connotes to me a rather thorough level of diligence in reviewing the law of the foreign jurisdiction.
Well, the procedural aspects were all set forth in the police report. The judge said during the recess what she was going to go do was read the police report, and that's all on there. What the actual laws aren't. She would have had to go to Westlaw to look these up.
Well, even, I mean, I understand that our technology in the Massachusetts courts is not where we would like it to be, but I'm confident that the Bristol Superior Court had access to Westlaw and Lexis.
Absolutely, Your Honor, and there would have been some indication somewhere in the transcript, somewhere on here, that these laws were looked at, that these laws were part of it. And
well, but there isn't, and you're saying that we need to conclude from that, from the failure of the judge to place that on the record, that she did not do it or was not otherwise aware.
Well, it should have also included a explicitly discrediting TRIZAN's explanation as to why he called his ex so many times, since that would have taken the calls probably into the realm of protected speech if you credit that. If you don't,
I'm sorry. Could you say that again? I just couldn't hear what you were saying.
If you don't explicitly discredit his explanation of why he's calling his ex, that he's trying to find out how his child is, you'd have to find that he didn't mean that. You don't believe that the judge didn't believe that he really was calling to harass.
The judge was certainly entitled to conduct a weighing of the evidence as it was recited, and was not required to credit the defendants, the probationers' attempt to explain it away. These calls were rather repetitive, were certainly in fact annoying, and when asked by the Florida officials, he failed or declined to offer any details about the urgency that he was claiming to justify the repetitious calls in furtherance of the well-being of the child.
There's plenty in there with which you could use to discredit his explanation. There's nothing in the record indicating that the judge did anything like that. It appears that the hearing was pretty rushed and conclusory as to whether he actually violated his probation. A clear statement on the record. This from the police report constituted the violation of this law. Ideally, mentioning a section would be enough for him to know. what he's being violated for and be able to disagree with it meaningfully.
What's your case support for the argument that the judge was required to make those explicit findings of what she credited or discredited about the evidence that was presented?
I don't have direct case law stating that. What I do have is case law saying that the judge has to be making an independent determination and can't be just relying on the determination of another judge. It's with the judge here. They had the facts but not the law. It puts the judge in essentially the same position as the judge in Commonwealth v. Jones, which was an unpublished decision from that last year. The judge in that one had a 209A order that it issued against the probationer, but they didn't look at the affidavit. And the appeals court said that they had the law but not the facts, and so that wasn't enough to say he created a new crime since it's different elements and different standards. And if the different elements and different standards didn't make a difference, then that would have been sufficient to just look at the 209A order. But here, the elements and the standards are different in the Florida laws than they are in the Massachusetts laws. Without both pieces, the facts and the law, it's impossible for the judge to be making an independent determination that the probationer is entitled to.
But not to put too fine a point on it, but you are again asserting as a necessary conclusion that the judge did not consider Florida law by virtue of the absence of an explicit statement on the record that she did. And you are making that assertion without any basis that I'm aware of in legal authority, because facts and law for this purpose are different.
And it's possible that could have been a responsibility that should have fallen on the shoulders of the defense attorney. And Commonwealth v. Santos, Commonwealth v. Santos c. Santos, another unpublished decision from past April.
You know what? I think, just speaking for myself, I was here when we decided Chase v. Curran and decided to suspend the prior embargo against citation to unpublished decisions. Mm-hmm. And while it's certainly permissible for you to make reference to them, I will tell you that for my purposes, they are falling on deaf ears.
Understandable. Essentially the issue with this is that there is not enough of a record to be sure that the judge did the right thing.
Let me ask you this, because the reference keeps being made to a police report, but what we really have here, it's a probable cause statement, right?
Yes, but aren't all police reports essentially probable cause statements? They're used as the probable cause for...
They're not. Now, in this case here, it's also, in addition to a statement of facts, the charges are actually identified. Harassing phone calls, 3 counts, with a specific reference to a Florida statute. Aggravated stalking, again with a specific reference to a Florida statute. Now, would your argument be strengthened at all if none of that was mentioned?
It certainly would be that you wouldn't even have been able to see which law might have fit.
Aha. So the fact that it is mentioned, can we draw the inference that the judge was aware of what Florida law was involved here, and that she would have, through due diligence, would have made an inquiry as to what it required?
It's just so difficult to believe that there would have been no mention of it on the record whatsoever. If she'd reviewed those statutes, they would have said, well, I've reviewed the statutes. I'm convinced that this constitutes a violation of the Florida statute. It's just...
But again, you are asking us, in effect, to create a rule that where a judge examines law of another jurisdiction, they must say that they have done so on the record. We don't require that for the judge on... We examine the law, and the judge can examine the law, and the judge is presumed to instruct themselves correctly on the law.
Well, if there are no further questions, I'll rest on my brief. That seems... I don't have an answer to that I think this court's going to accept.
You've also made some suggestions that the judge ought not to have treated the hearsay as reliable, and we understand that argument as well. Thank you.
Thank you.
Good morning, Alicia Sanchez for the Commonwealth. May it please the court. I tend to speak softly, so please let me know if I need to raise my voice. I just want to correct something that I indicated in a footnote in my record appendix. Page 4 of the probable cause affidavit was in the court's file. I revisited the clerk's office on Friday and confirmed that it was, page 4 was before the judge. I apologize for any confusion on that. So here the judge, if you look at her findings, she used the appropriate standard, preponderance of the evidence, and she looked at the evidence and found that it was substantially reliable hearsay. She made an independent finding that the defendant had violated Florida law. There's nothing in the record to indicate that she did not know and that she did not correctly apply the law. There's the presumption that she knew and correctly applied it. If you look at the probable cause affidavit and the Florida statutes, you'll see that there was sufficient evidence to support her finding that the defendant had violated his probation and had violated the Florida law. I'm happy to answer any questions on any of the other issues. If there are no questions, I'll rest on my brief. Thank you.
Could I ask one question? With respect to the data mining issue, is there a basis for us to consider any of the information that came in or that was noted to be the result of data mining with no further explanation as reliable?
Yep, so the data mining issue, we don't know where exactly that information, the record doesn't show where that information was obtained, but we can find it substantially reliable in the sense that the Florida judge relied on that in determining that there was a probable cause statement, and the fact that it does reference the 2010 underlying case in this matter. But beyond that, we really don't need that for this document to be substantially reliable hearsay. Really, all we needed under the Hartford factors is that there's a statement from the victim with her direct knowledge. The statements were factually consistent. It was detailed. And then there was corroboration by the police. They had subpoenaed records. And then the defendant himself indicated that he made the phone calls. So really, with that in itself, that made the document substantially reliable hearsay evidence.
And could I ask one other question? Is there anything in the record that I've missed that explains the reason for the delay in the issuance of the violation notice in this case?
So there's nothing in the record that explains the delay. The timeline is essentially the incidents happened in July of 2021. The probable cause affidavit gets signed in October that year. November 16th, his probation is due to expire. 3 days later, he gets the notice from probation. And then there's a 4-month gap between when his probation was due to expire and the judge's order. Under Sawicki, that's permissible. The court had the power to revoke probation because all of that, the probation and the court acted with reasonable promptness. But unfortunately, I don't have any answer as to exactly why there was a 3-day delay or why Florida had a delay.
And the defendant was on administrative probation at the time that the alleged violation took place. He was living in Texas.
Yes. There are no further questions. I'll rest on my brief.
Thank you. We will take a recess of about 15 minutes. We will resume at 10:45.
Thank you.
Ron, do you see about the microphone?
This court is now in session. Please be seated.
We continue our hearing list with the civil portion of the arguments this morning. This case is impounded. It's a case involving child protection. Please refrain from any reference to the names of any of the individuals. Refer to them by mother, father, child, etc. This case is case number 2022 P1077.
Good morning, Justice Green, Justice Hodgens, and Justice Hand. I want to thank the court for greeting me with the smiling face of Justice Graney. I remain in such admiration of his courage as a single justice in applying 28 U.S.C. 1738A to DCF, such that the decision in care and protection of Vivian resulted and such fine, important guidance was provided to the bench and bar. I did not know I would be greeted with his smiling face, and you made my day. So I needed to let the court know that. Now, going
Attorney
forward,
Butler, when the next time you go over across the hall, you'll see Chief Justice Armstrong's portrait in that courtroom now as well. We've renamed that courtroom the Armstrong Courtroom, and both of those portrait ceremonies were incident to the celebration of our 50th anniversary last October. Before we get into the merits of the case, as you're aware, we do have a motion to dismiss that the department filed, and you filed an opposition. We indicated that we would allow that to be presented and argued at this hearing. So why don't you address that first?
I thank you, Your Honor, for having given me advance knowledge of that. I came prepared to do just that. And as Your Honor noticed, my opposition was filed within 24 hours of that late motion to dismiss, where the dismissal issue was not briefed by any of the appellees, where in the trial court, none of the parties moved to dismiss the notice of appeal filed by my client, and where the cases used to argue for dismissal, including Deborah, are easily distinguishable. I was surprised.
Let me just make one observation, and that is that if I understand things correctly, the principal event giving rise to the argument that the current appeal is moot was the entry of final judgment in the Michigan divorce that awarded custody of the children to the father. That, as I understand things, took place a little over a month ago.
Your Honor, first, I was surprised when the motion to dismiss was filed by appellees that they cited to neither care and protection of Joe Zolito nor care and protection of Yerrick, especially whereas here, Yerrick was an effort by the same trial judge, Judge Johnson, to not have Joe Zolito and its double-edged sword apply. As to the judgment and events in Michigan, I received a purported judgment from Michigan only the 15th of September. I contacted my client because I had not heard about it or been apprised about it, and she stated to me that she was unable to participate, they wouldn't let her call in, and she wasn't sure about it. I'm not saying it didn't happen, Your Honor, and I'm looking at General Law 209B 2A1, and our proceeding was in place before that. And interestingly, the Michigan court apparently was provided the orders out of Norfolk County. Their court states, and I refer to their ex parte order, which I did have at the time of briefing, of 782021, this court further takes notice of the findings and ruling of the juvenile court in the County of Norfolk, State of Michigan, Massachusetts, which awards custody of the parties' 3 minor children to plaintiff father and awards supervised telephone or video conference parenting time to defendant mother.
Let me just zero in on my question, because my understanding is that however we got there, there is now a final judgment entered in Michigan with jurisdiction over the parties that issued a final decree of divorce awarding custody of the children to the father. Your challenge in this appeal is to the award of temporary custody, at least, of the children to the father, subject to review and redetermination, by virtue of their need of care and protection. What relief could we award to you or your client in this proceeding that would not be precluded by giving full faith and credit to the Michigan decree?
First, Your Honor, whether or not the Michigan decree should be granted full faith and credit, given General Law 209B, Section 2A1, is not a settled matter. That's problem number one. Problem number two is, to the extent which is unknown to myself or my client, that the Michigan court based its action on the fact that findings that are under appeal were provided to it, and my client was not...
A challenge to the reliance of the Michigan court on the Massachusetts proceedings could have been lodged during the course of that divorce if it were contested. I can't tell from the decree. It looks to me as though that decree was entered by stipulation, and I suppose we can find out more about that. But the
the stipulation
in any event, a collateral attack on the decree after it entered, based on the contention that it rested on materials from another jurisdiction that were flawed, that ship has sailed.
Your Honor, first, the portion of the document that states stipulation was crossed out and initialed by the attorney appointed to represent the father. Talking to my client, she authorized nothing and stipulated to nothing and was not involved in the proceedings whatsoever. She neither had the financial or physical ability as a disabled, destitute person to go to Michigan, nor did the Legal Services Corporation provide an attorney to her. And she tells me, which is all I have, I contacted her on the 15th, which is when I was sent this.
I understand, but that decree supersedes the award of custody, temporary custody, by the juvenile court here. And if there are challenges to be made to that decree, if there are challenges available to be made on due process or other procedural or substantive grounds, it seems to me that's an entirely separate question. My question to you is, what relief could we award to you that would not conflict with the Michigan decree?
First, if this court were to examine whether under General Law 209B, 2A1, the jurisdiction of Michigan was appropriate or not. I didn't brief that. I did not have access to this judgment, but I did check the jurisdiction statute. And I am very familiar with 28 U.S.C. 1738A, and whether or not there is continuing exclusive jurisdiction
that decree
in the
entered.
state.
Again, if there is a challenge to be lodged against that decree on jurisdictional, procedural, or any other grounds, this is not the forum or the procedural vehicle through which to do that.
Secondly, Your Honor, based on both what is in the temporary order and what is in the alleged judgment, the holdings by the Norfolk Juvenile Court that my client was unfit were relied upon in Michigan. If, in fact, that is not a valid holding or is not supported by clear and convincing evidence.
Again, the forum in which to challenge those to the extent that they were being relied upon by the Michigan court was in the Michigan court during the pendency of those proceedings.
Your Honor, if the order itself is invalid and was relied upon, I submit that should this court determine that that was invalid and should that be submitted in Michigan, that is, in fact, a relevant possibility.
How could it be submitted? That proceeding is concluded. The effort to, any effort to challenge the validity or the basis for those findings in Michigan could have been brought in Michigan and wasn't.
Your Honor,
at this point, the only relief that you could ask us to provide would be to vacate the award of custody, and that is something that, as far as I can tell, by virtue of the Michigan decree, is not available.
Your Honor, that is not, in fact, the only relief requested. And I draw the court's attention to Mother's brief in the specific requests made as part of the conclusion. While I understand that the court is not inclined to look at the jurisdictional issue, the fact that, one, this case began the way it began because there are no Fourth Amendment protections granted to children or parents in this jurisdiction, whereas in 5 federal circuits, the Fourth Amendment has been held to apply. That case law was provided to this court.
But if we determined that this challenge was moot, we wouldn't be deciding that question, or we wouldn't be in a position to accept your invitation to extend that, even if we were inclined to do so, correct?
There is, when an issue is capable of repetition, when it affects children and families across the Commonwealth, then that issue itself is not moot.
Well, it's
this
moot.
court decides,
we may, in our discretion, reach a moot question if it's an
that
issue
is
of significance.
that is correct, Your Honor.
Excuse me.
Your Honor.
One other question, counsel, just to, for my own purposes. This may not bear directly on your argument, but is there any remaining legal impact of the determination of mother's current unfitness, given as to the 3 children at issue here, given the fact that there has been a divorce judgment entered granting custody of those children to the father? Is there any remaining legal impact of that decision on the mother?
Your Honor, it may be a factor that would be considered in terms of what kind of parenting time she gets under Michigan Law 772, which I provided the cite for in my opposition. It's also concerning that although her parental rights weren't terminated, in practicality, she was treated as though they were. And the kind of analysis that this honorable court used in EK versus SK really didn't occur. Mother does continue to deny that she is currently unfit, but the way the ICPC was handled and the denial of the stay by the trial judge, which was the subject of a single justice appeal prior to my involvement, meant that the children had resided in Michigan for 15 months before the care and protection trial, which did place her at a real disadvantage. Were mother not to be found unfit, my read of the Michigan statute is that that would place her in a stronger position in exercising her parental rights there. Also, looking at the actual wording of General Law Chapter 209B, Section 2A1, this court retains that ability in this situation, in the procedural history of this case. And mother was entitled, as was her trial counsel, to rely on the judge knowing what the judge was doing when he expressly retained in the earlier motion her full appellate rights. And the tactical decision not to appeal that occurred before my involvement in this case. And that was relied upon by this woman who, at the age of 41, had a very difficult pregnancy, a very difficult placenta previa delivery, and an episode of extreme illness. And frankly, the way she was treated does not pass muster. She did, through her counsel, file a motion to stay the removal, and not only was that ignored, the children were whisked off to Michigan without even a farewell visit.
All right. We have your brief. You can rest on your brief.
Thank you very much, Your Honor.
Thank you. So I understand you're dividing your time. You will have 7 minutes for the department.
Thank you. May it please the court. Jennifer Kernan for the Department of Children and Families. I'll address our request to dismiss the case as moot first. And primarily, the motion to dismiss was based on the grounds that Michigan has assumed jurisdiction. And here, just by way of a brief overview of the timeline, on June 30th, the juvenile court found mother unfit and awarded permanent custody of the children to father, who had by that time been living in Michigan with father. On July 20th, and before I move on to that date, when the lower court judge issued his findings on the 30th, he did make note that if father were to obtain an order out of Michigan, that he would dismiss, the Massachusetts juvenile court judge would dismiss the pending petition. And that's what happened. On July 20th.
Help me understand, because I've tried and I've been unable to assign any meaning to the purported reservation of appellate rights from the order in the juvenile court dismissing the C&P.
I think the department is in the same boat as Your Honor. The department's
Judge signed that. What is? I'm struggling to understand what it was intended to be.
Same, Your Honor. The judge did make a notation saying that the case remained open for appellate purposes. However, the docket actually reflects that the case was indeed dismissed on July 27, 2021.
Just in terms of understanding where that occurred in the procedural trajectory of this case, that took place at a time before the appeal had entered in this court. Is that correct?
That is my understanding.
Because once the appeal enters in this court, the trial court would have been without jurisdiction to take any action on the underlying C&P.
That is an excellent point. My understanding is that father's motion was filed on the 20th. Mother's initial notice of appeal was filed on July 26th was her initial notice of appeal.
That's just the notice of appeal. I'm talking about assembly and then entry on
Right.
this docket. I can look, I guess.
And I wish I were certain, but I imagine that it would be some time from the notice of appeal, given that it usually takes a couple months to assemble the record.
There's an answer to that because it will show on our docket, and I don't need to take up more of your time. We'll look at that.
Quite all right.
It entered on November 3rd of 2022.
November 3rd of 2022. So that was well over a year after the court.
After the CMP was dismissed.
Correct, yeah. The motion to dismiss was allowed on July 27th, and the initial Michigan order had been attached to father's motion to dismiss. So yes, over a year between.
And yet, during that time, the clerk's office of the juvenile court assembled the record of a case that had been dismissed.
That is correct, and I think that's illustrative of how confusing that notation was. But the fact does remain that Michigan had assumed jurisdiction at that point. And as Your Honor made the point, there's no order or action that this court could take that would change Michigan's order or the outcome in Michigan.
2, 3, 4 of you briefed this case.
Correct.
All of you publicly compensated.
Correct.
Starting just about a year ago. Okay.
If the court would like me to move on from the mootness issue, I'll be happy to address the unfitness that even if this court were
We're here. Go ahead.
If this court were to determine that the case is not moot and should not be dismissed, the trial court's findings are amply supported by the record. Here, mother's mental health illness, her untreated mental health issues severely impacted the children, and that was prior to removal. The record, particularly mother's medical records that were submitted as evidence and that the lower court considered, indicated a severe, long-standing mental illness with multiple hospitalizations. And that mental health illness affected the children in a number of ways. Mother moved the children from New Hampshire to Massachusetts after only 3 months due to mother's concern about the water in New Hampshire. Mother's delusions prevented an IEP assessment for the middle child because she stated they were relocating as a result of the harms and crimes sustained and caused by local government agencies. The children observed mother be physically violent to the father. In one of the episodes in November 2018, the middle child who was present during the incident dropped to the floor, banging his head and kicking and screaming during that incident. The oldest child has flashbacks of her time with mother. She recalls mother hitting father, mother telling him she would murder him in his sleep, and father clutching his chest in pain during an argument, asking mother to stop, and mother laughing. This behavior did not change after the removal. The department designed a service plan to address mother's parenting deficits, and the primary focus was indeed her mental health. However, mother did not comply with those service plans related to her mental health, and as a result, was not able to make any changes to her parenting ability such that it would be safe for the children to return home. Specifically, mother disregarded the department's advice about topics of conversation that were appropriate for the children, and continued to make disparaging comments about the case, the department, and even father. With regards to visitation and overeating, mother had been informed that the middle child had difficulty overeating and needed to be told when to stop eating. Yet mother continued to bring unhealthy food and encourage him to eat as opposed to address the issue that had been brought to her attention. Mother continually put her needs above the needs of the children, despite recognizing their struggles. Thus, it was not error for the court to conclude that mother's mental health negatively impacted her ability to care for the children. And if there are no other questions, I will rest on my brief.
Thank you.
Good morning, Your Honors. Tamika O'Brien on behalf of Father. Your Honors, I don't have a lot to add to today's argument. I believe that my sister adequately addressed the motion to dismiss here, but I would like to remind this court that father's fitness was not at issue at the time of trial. I think that the one thing that...
Well, the father's fitness also was not adjudicated. There's no issue in this appeal concerning father's fitness, right?
Correct.
Okay, so we don't need to talk about that.
I think, so that I'm not repeating everyone else here, I think it's important to address the implication that perhaps because DCF placed the children with the father in Michigan, that was in effect a de facto termination of mother's parental rights. That is not the case here. Mother did have an opportunity for phone calls, video calls with the children. She rejected both of those. She didn't want to go to the DCF office to have them supervised, didn't have a computer, refused to accept a computer from DCF so that she could engage in those kind of visits. Also, this was during COVID, and it's unfortunate, but it's a fact that in-person visits weren't happening, or if they did, it was rare. So her visits, I argued, were no different than anyone else's visits. And the alternative to placing the children with their biological father, who had a very strong support system, and DCF didn't have any concerns about his parenting, was to essentially split these children up and place them in various foster homes throughout the Commonwealth. And at least having them in Michigan with father and with aunts and uncles and children that they can play with, these children were together as a family unit. And I think that that is the most important. So the argument that there was basically de facto termination here is just not warranted. If your honors don't have any other questions, I'll rest on my brief. Thank you.
Good morning, members of the panel. May it please the court. My name is Joe Desmond. I'm here for the 3 children in this case. First, on the motion to dismiss in the Michigan jurisdiction, I did not originally join that motion because I did not at the time have the Michigan judgment, which was subsequent. It's just dated in August. When the judge closed the case, I think he was careful to say, I'm closing, not dismissing. I think he left certain avenues open to mother, and I think one of those would have been a review and redetermination, which was available to her after 6 months, also in a sense keeping her appellate rights open, also in the spirit of what the judge was ordering.
So you were there?
No. I was not at trial, Your Honor.
I was hoping you might be able to offer some insight into what the judge intended or what the parties intended, because when the underlying petition is dismissed on grounds that jurisdiction over the matter and the custody of the children, the question of the custody of the children, has been assumed by a valid foreign jurisdiction in the context of a divorce action. I still don't understand what it means to have a preservation of appellate rights from the remainder of the case here.
My insight into what the judge intended would be taken from his action on the motion to dismiss, which was filed at the trial but before the first witness testified. The department filed a motion to dismiss saying we have no protective concerns for any of the children. We seek to dismiss. The judge said, and the only party opposing that was mother. The judge denied it and said, in the interest of fairness, I want mother to have her trial. It's almost to say she's owed her trial. We're giving her that. So I would take that to mean that she can't have a trial but also be deprived of the appellate rights surrounding the trial, so the judge needed to preserve both. And therefore, I think that's what that's, if I was to read his intentions, that would...
I hear the words. I'm still struggling to find meaning.
And I'm not defending the action of the judge, but I would say that by giving Michigan jurisdiction, this was opened up as a result. With a review and redetermination, it would have been only 6 months. This took 2 years to play out. Invariably, Michigan, we were inviting Michigan to issue a judgment on the case. That's what happened. It's unlikely that would have happened in 6 months. So I think in the judge's original pursuit of fairness, mother could have accomplished that by taking a different appellate route than this one. In terms of the merits of the case, and by the way, also in terms of fairness, I would also point out that the Michigan case began at the onset of the COVID-19 pandemic. I think it's a reasonable inference that mother had availability to those proceedings virtually, as that was nationwide at the time. So I think throughout the Michigan case, despite mother saying she could not access that, reasonable inference, and I think it's also can be inferred from the judgment itself that she did participate to some extent in that case.
We don't know. We don't have a record, but it is what it is.
In terms of the merits, I would just stand on the brief, and the children do support life with father as it stands.
Thank you.
Thank you.
The next case on our list is case number 2022 P445. This case involves a level 2 classification by the Sex Offender Registry Board. The case is impounded. I will again remind counsel to refrain from reference to any of the impounded materials. As a reminder, we are live streaming this argument, and it will be available on our YouTube channel, so please be ultra careful.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant in this case. As you know, the Sex Offender Registry Board has classified my client as a level 2 sex offender. I'm here today requesting that this court either lower my client's classification level from a level 2 to a level 1 or remand the case back to the board for another hearing. And the reason for that, I would assert that the decision was arbitrary and capricious, and the hearing examiner abused her discretion because she misapplied 2 of the regulatory factors that the board has. One of them is regulatory factor 30, advanced age. Instead of applying significant mitigating weight to this factor, the hearing examiner only gave it full weight.
Wouldn't that, in regular usage, understanding what the regulations use as far as their terminology, but wouldn't in regular usage full indicate perhaps something greater than substantial?
So the words they use is significant mitigating, and that would signify something even that applies more than the full weight, than giving it the full weight, because if you read the regulation.
But it would be full mitigating weight. I mean, how much more mitigating weight could be given than full weight?
So the way I read the factor, if the person is in their 40s, this factor would apply. It would apply fully, unless there's a reason to take away weight to it. But if you read the second paragraph of the regulation, it says that if the offender is in his 50s and didn't sexually offend a child, then significant mitigating weight, so in other words, more mitigating weight than just a threshold weight would apply to this case. And I would assert that the hearing examiner should have given this, according to the words in the factor itself, significant mitigating weight, which I would assert is something more than just a threshold application.
So in other words, while the ordinary language might suggest that full is everything and significant is a lot,
Yes.
Therefore that full would be more, in the context of the structure of these regulations, you would argue that it's a stepped progression.
Exactly.
And that the extent of the weight increases as the offender ages.
Gets older, exactly. So that's my first assertion, is that the hearing examiner made that mistake.
But the examiner, in the footnote 8 said, I have given the petitioner full credit for his advanced age. So, I mean, there's really nothing beyond full, is there?
Well, I would assert that if the way the paragraphs are written within this factor, significant mitigating is more than full, because the older the person gets, the lesser their chances of offending gets. And so they deliberately include that in there when the offender's in his 50s. So that's what I would assert to this court. In addition to that, I would say that the hearing examiner should have given my client full instead of moderate weight for risk mitigating factor 33, which is home situation and support system. As you'll see in the record, my client was in a stable home. He was living with his long-term fiance, and also had the love and support of his adult children. So because of those reasons, I would assert that the hearing examiner should have given it full instead of moderate consideration. As you know, my client sexually offended in 1989. That was over 30 years ago. He was 22 years old when he sexually offended, and as we sit here today, he's close to 57 years old. He only has one sex offense on his record. He was involved in parole at the time of the classification hearing, and part of that parole involved GPS monitoring, but also sex offender treatment, and he was involved in sex offender treatment. He was attending regularly, and he was an active member of sex offender treatment. He has had no issues with drugs or alcohol in just about 2 decades. And as I indicated, he has the love and support of his family, including his long-term fiancé and his multiple adult children. So because of these reasons and because of the errors, I would assert that this court should either remand the case for another classification hearing or on its own lower my client's classification from a level 2 to a level 1. And for the same reasons, I would assert that my client should not be on the internet for active. Even if he remains a level 2, his information should not be actively disseminated to the public, again, because of the age of how long ago he committed his sex offense. It was only one sex offense, and it was over 30 years ago. And if there's no further questions, I'll rest on my brief.
Seeing none, thank you.
Good morning. May it please the court. Roxanne Greenaway for the Sex Offender Registry Board. I want to draw your attention in particular to Factor 30. When you look at the language of the regulation, nowhere in there do you see full, moderate, or any type of descriptive of the weight. What you do see is the regulation indicating that significant mitigating weight should be given after age of 40. And as Justice Hodgens pointed out, in Volume 1, page 32, the hearing examiner, footnote 9, indicated that she gave full credit for advanced age.
Right. There's a difference between full credit and full weight, I suppose. Full credit would mean giving the credit that the regulations require, meaning significant weight.
If you also look on page 32, Your Honor, in the body of the decision, you will also see there that the hearing examiner indicates this factor applies with full weight. So it's both full credit and full weight. There is no more to give than full, and he's not entitled to more than full. So I would rest on that. With regards to Factor 33, as the court knows, the hearing examiner has discretion to consider which regulatory factors to apply and the weight that's given to those factors. And in this particular case, I would even point out, if you look in the plaintiff's brief on page 15, footnote 7, it indicates it was fair for the examiner not to give Doe greater mitigating consideration for this risk mitigating factor, since, as the examiner indicated, the fiancé believed he was wrongly convicted, and she failed to provide details on how she would support Doe. So they concede the point in their brief as to why the hearing examiner moderated the weight of that factor. She obviously gave credit, mitigating credit, for having the support system. However, they did not meet all the prerequisites of that factor to get the most weight out of that factor. She did not believe he was convicted, and she did not give a description of how she would support him and help prevent further recidivism. Now, when you look at the timeline, I understand that the crime took place in 1989. He pled guilty thereafter, May the 29th of 2003. And upon his release, shortly after his release, he committed an attempted murder and was sentenced for quite a long period of time, 15 years. So this is an individual, although crime took place a long time ago, has been incarcerated, not only for his sex offense, but thereafter for a significant period of time. And so you will notice in the hearing examiner's decision, you do not see any mention of Factor 29 because it doesn't apply for the offense-free time in the community, because he had not yet been in the community for at least 5 years. So I would just rest on my brief with regards to the hearing examiner's application of those two factors. And the same with the internet dissemination. When you look in my brief, you'll also find that the hearing examiner took a balanced and fair view, giving mitigating weight to those factors that did apply to his situation. But upon balancing those factors, looked at the crime that he had committed and indicated that women in the community who may be in a position to enter into a dating relationship with this man, who has no clue as to his background, would know that he is a dangerous person, especially with the proclivity towards hostility towards women that he had exhibited over the years. He was on probation for violence against one woman when he committed the sex offense. And then after the sex offense, he stabbed another woman and almost killed her. So I will just rest on my brief if Your Honors have no further questions, and ask that you uphold the hearing examiner's decision.
Seeing no questions, thank you. Thank you both.
Thank you.
That brings us to the sixth and final case on our hearing list, case number 22, case number 2022P784. This is another case involving a sex offender level classification, and the case, as was the prior case, is impounded.
Good morning, and may it please the court. My name is Attorney Josh Daniels, and I represent the plaintiff in this case. I'd actually like to take the issues out of order from how I briefed them, beginning with the substantial evidence issue to make sure that I get to it, because I do think that it's actually the more fundamental problem here. And just to set the table for that issue a little bit, I think we all agree that to classify my client ED as a level 2, the board had to prove by clear and convincing evidence, in other words, to a high degree of probability, that his current risk to reoffend sexually is at least moderate. And our suggestion here is that given the constellation of facts as found by the hearing examiner himself, the record simply does not and cannot support that finding. My client has no high-risk factors. He's in his late 50s. He's almost 60 years old. He's reached advanced age. As of the time of his decision, he had 8 years offense-free in the community. He now has accumulated over 10. He hasn't misbehaved in any way in 20 years. And his only other criminal history is minor and even older than the index sex offenses for which he was required to register. And he's currently in treatment, and as the hearing examiner also credited, he has significant family and community support and stability. If basically our position is, if this is what current moderate risk to reoffend looks like, then I don't understand how those words have any meaning at all. I would suggest this isn't like many other cases that this court has seen and that I have come across in my own research, where the court upholds the risk finding either because of usually two things. A, there's high-risk factors that limit how much the mitigators can help, or B, the mitigators are themselves undercut by evidence in the record of recent misbehavior. Again, here, literally every fact that points in the direction of risk is 2 decades old or even older.
But don't the regulations take that into account by including static factors as risk elevating? It's not a surprise that the risk elevating factors include certain points that apply to your client that aren't going to change over time. The nature of the offense, the number of offenses, the relationship, those kinds of things.
I'm sorry, I'm having a little trouble hearing you, Justice Hand.
Okay, sorry. My point is that many of there are some issues that you raise about the fact that there are older facts that play into the factors that applied here, but that's built into the regulations, correct?
It is, but I keep coming back to this is supposed to be an assessment of current risk. And I don't understand, and I can't figure out from the hearing examiner's decision, I think because it's frankly inexplicable, how you can get to a current moderate risk when every fact that points to risk at all is 20 or 30 years old, and there's nothing more recent, and there's powerful mitigation that is current, that the hearing examiner credited and purported to give significant weight to. When you come down to the hearing examiner's bottom line, it just seems to be, I find by clear and convincing evidence that the current risk is moderate. Here are the factors I applied at the weights I applied them. I find by clear and convincing evidence that the current risk is moderate. There's no sort of rationalization of how the mitigators fail to outweigh the static factors and the other older information. And I think the hearing examiner doesn't explain it because there really isn't anything to explain. I also, as I note in my brief, I think the hearing examiner's the hearing examiner's finding on risk to reoffense rests in part on the weight that he assigned to factor 10, which I view as equally inexplicable. The offenses that he considered for factor 10 purposes I think they couldn't be more minor. They consist of nonviolent regulatory motor vehicle offenses that were continued without a finding in 1993, and simple drug possession offenses, again nonviolent, that were, I believe, null prossed or otherwise dismissed in 1989 and 1990. We don't have any police reports about these charges. We have no idea how they arose. All we have is the Board of Probation. And I mean, I don't see how this points to or rationally shows ongoing or persistent criminal behavior or disregard of the law, which is the touchstone according to factor 10 as it's written. I think at most it should have gotten minimal weight, as the hearing examiner gave to factor 9, based in part on the exact same criminal record, the drug offenses from 89 and 90. I also, as I say in my reply brief, I don't think this is waived. I think the papers below, I might have drafted them a little more, I might have fleshed out the point a bit more, but I think at bottom, the papers argued that there was a lack of substantial evidence based among other things, the lack of any misbehavior for 20 years. If you look at record 324, as to risk of reoffense, Mr. D has not sexually reoffended since his 2003 convictions, nor has he committed any non-sex offenses. I think SORB itself was fairly on notice that factor 10 was an issue, and you can see that because they decided to defend the weighting of factor 10 in their own papers. That's at record 345 and 346. That's all I have on the substantial evidence issue. On the funds issue, I don't really have that much more to say about it beyond what I've said in my briefs. So basically here, the hearing examiner's stated reasoning for denying the funds is a reason that the board itself before you doesn't even try to defend, which I take as a suggestion that they recognize, perhaps tacitly, that it's inadequate on its own. And instead they try to argue, they try to offer up an alternative rationale that the hearing examiner never gave, and that if anything is in the teeth of the hearing examiner's own finding, crediting my client's affidavit that he's been receiving Social Security or SSI benefits for these mental health conditions that he identified since 2015. Baked into that is necessarily the notion that he must have proved to the federal government's satisfaction both the existence and the extent of these disabilities. So I don't see how the board can argue that he hasn't substantiated them. And given that posture, it's hard to see how you could affirm on this basis because, as we all know, from DOE 58574, among other cases, the board can only defend its decision based on the reasons it gave when it acted, and you can't really affirm on a ground that's different from the one the agency gave at that time when it made its decision. So I think on the funds issue alone, the case really does need to be sent back. I would ask that on the substantial evidence question, viewing the record as a whole as you're required to do under cases like New Boston Garden and DOE 11204, that the evidence before the hearing examiner cumulatively tends substantially towards the opposite conclusion that he reached, And therefore, I would ask that you, if you do remand, that it be remanded with an order that he be classified as no more than level 1. I don't, if you have any questions, I'm happy to take them, but I really don't have anything else.
I have a question for you.
Yes.
On paragraph 7 of the motion for funds, it says medical records indicate that the petitioner suffers from various mental and physical conditions, including but not limited to PTSD, major depression, anxiety, and agoraphobia. Were those medical records presented to the examiner?
They were not, and I say they don't have to be, because the way that the SORBS regulations are written, you have to submit supporting documentation or affidavits verifying the special condition on which you're relying on, which I think the plain language of that regulation means that either one will do if it's credited by the hearing examiner. And on this point, at least, on the point of whether my client has been receiving SSI for these conditions since 2015, the hearing examiner did credit his affidavit.
My question, I guess, goes to the inscrutability inherent in this entire regulatory scheme. Substantial evidence, as you're aware, is a decidedly low bar. It's not preponderance. I mean, it's really, it doesn't require a lot of factual material. As Justice Hand has observed, these regulations permit a level 2 classification based on a hearing examiner's weighing of evidence that includes factors that date back quite a long time and have not seen recurrence. And while one may argue that the hearing examiner was more rigid or harsh than was necessary, it's hard to see that it was outside the range of permissible assessment given the range of discretion and flexibility in the application and weight of the various factors applicable. There's no indication here that the hearing examiner, for example, applied an impermissible factor or applied a permissible factor in an impermissible way.
Aside from factor 10, you mean? Or?
Right.
So I have two thoughts about that question, Mr. Chief Justice. The first is, I'm not sure I agree necessarily that the case law supports the idea that substantial evidence is as low a bar as perhaps the court applies when reviewing a lower court judge's decision. I note, for example, the language from New Boston Garden that the reviewing court is not required to affirm merely on a finding that the record contains evidence from which a rational mind might draw the desired inference. So I think there is a little more room for second guessing the agency on substantial evidence.
But it is lower than in fact than we apply to the findings of fact of a lower court judge, which is clearly erroneous, right?
Fair enough. My second response is going to what you, I think, aptly call the inscrutability of this decision-making process. I think the fundamental problem that we're encountering in these cases, and I watch all the oral arguments, I've heard you and your colleagues make comments to this effect before, is there really aren't any rubrics that explain how you're supposed to differentiate a high risk from a moderate risk from a low risk, either in terms of—
That's my choice of the word inscrutable.
Yes, either in terms of numbers or anything else. So, I mean, basically we're left in a world where if the board doesn't articulate any standards for its hearing examiners to follow, then no one can say that they're wrong. And what we get in that world, I think, is a system that inherently invites arbitrary and capricious decision-making where the outcome of the bottom line is essentially varying with the length of the hearing examiner's foot. And I don't know how you can reconcile that with either due process considerations or with the requirement of reason, consistency, and administrative decision-making.
Thank you, Mr. Daniels. I think with that's an opportune segue for us to hear from Mr. Chennai.
Thank you. I've never finished this early. I don't expect to do so for quite some time, but I can always try.
Well, I'm not rushing you away from the podium, but it did seem to me that we'd reached the end of what you had to say to us.
I think we agree on that point. Thank you very much.
If it pleases the court, David Chennai for the board. I want to start. I told the panel on Thursday that it seems interesting that I've got 4 cases in 5 days up here. I think you're trying to wipe out my caseload in
I wish
one
we could
swoop.
give you a free cup of coffee on your way out after so many appearances, Mr. Chennai, but that's just not the way that we're structured.
Well, more importantly, you dodged a bullet. Tomorrow is probably one of the last of the misapplications of Factor 2, so I'm interested to see how that's going to go. You know, I don't think this court's ever had a problem determining when the hearing examiner has made a mistake in these cases. I just don't think this is one of them. I think this is a pretty solid case based on the evidence. I mean, these are very serious sex offenses. I know they occurred 20 years ago, but he's only been in the community offense-free for a moderate period of time, which was the 8 years. And I think that factors heavily into the hearing examiner's decision on this matter. Then going over to the issue regarding the funds, no medical records were produced to confirm the allegations that the plaintiff made in his affidavit. He suffers from these conditions. And the hearing examiner gave them a chance to put that medical records forward. What the hearing examiner said was, and before the hearing, I deny it without prejudice, meaning that if you bring in evidence at the hearing, I may reconsider it. But no evidence was brought in the hearing again on these medical records. And I think that's really the gravamen. What the hearing examiner says, he doesn't produce the evidence that will show that the conditions he claims impact his sexual recidivism risk.
Well, isn't the statement that the medical records reveal that he suffers from these conditions contained in the affidavit of the expert or the treating professional?
Well, it's interesting. The expert says exactly what the motion says. The wording is exactly the same. So it's unclear where the expert found this evidence or knew of these conditions. But more importantly,
presumably, when they sign the affidavit, they are asserting, based on their personal knowledge, that the records say what they say they say.
Correct, but we don't have any evidence that this doctor saw medical records. It appears...
The doctor says that that's what they say. How could she say that that's what they say without having seen them?
I don't think she says the medical records say that. She says he's an individual who suffers from these conditions.
Right. I thought, maybe I misunderstood, and I will confess that I wasn't familiar with that aspect, but I thought that I heard Mr. Daniels say that she said that the medical records say that. She didn't say that?
I believe she said that she basically said this is what this individual suffers from.
That's what I recall reading.
Right, but more importantly, if you look at what the proposed expert said is, she didn't say that any of these conditions impact his risk to reoffend. What she said is, I need to do testing to get to that point to make that determination. And that's not what the expert funds are for. It's not to allow testing.
I understand. What about the SSI benefits based on those conditions?
The SSI benefits, again, was in his affidavit, and the hearing examiner basically gave him a benefit of the doubt on that and said, okay, I accept the fact that he gets SSI for these claimed problems. That doesn't necessarily correlate to proving that these problems, first of all, for a motion for funds, doesn't prove that, one, these conditions impact his risk to reoffend positively in any way, or two, that they actually exist. What she did, she said, the hearing examiner, what he said was, okay, he says that he gets SSI, I'll accept that, and gave him benefit for that. Didn't have to do that, but this is what the hearing examiner did. And I think that it was a fair way of looking at the evidence, to give him credit for that, which again, it's part of the reason why he's a 2 and not a 3. She gave him credit for these type of things, that he was stable, he had a support system. Interestingly, a support system that never really talked about what they do to help in the guidance of preventing him or rehabilitation of him or preventing a future sex offense. Basically, the hearing examiner still gave him full credit for that. The hearing examiner, I think, focused a lot on the fact that 8 years had passed. It's not 10 years where a substantial reduction, but it is 8 years. And that really is where we're back to the level 2 on this. And I think that it was a fair way of looking at the evidence. I don't think the hearing examiner was being extremely harsh on this individual because, again, he credited him for the claims that he gets SSI, and these are the conditions he gets SSI for. So I think that, again, was a fair way of looking at the evidence by the hearing examiner. And I think I've covered all of these issues pretty well in my brief, so unless there's a specific question, I'd be more than happy to rest on my brief.
Seeing none, that concludes the argument in this case, and with it, the last of the cases on our list for hearing. We are adjourned.
Thank you, Your Honor.